Friends, welcome. Thank you so much for joining us. We are thrilled. This is the first HLS PLAC event in person in 2 years. So we are just absolutely delighted to see all of you and all of you who are joining us online for the live stream for this event with our colleague, Dr. Danae Azaria, on state silence. Not all state silences speak. And she's going to be discussing with us a new paper on this topic, which we at PLAC are especially partial to. And we're thrilled that Dr. Azaria is joining us for this first event back in person. So I will just alert you to the fact that this event is being both live streamed and recorded, so you are on notice. And we will have a walking mic when we open up the floor. So my colleague Dustin will bring a mic, so please wait till he gets to you before you answer your question. And we'll have about 30 minutes of remarks and then open for questions, answers, and comments. So Dr. Danae Azaria is an associate professor at the Faculty of Laws, the University College of London, and the director of the State Silence Project, funded by a grant of the EU's European Research Council. She's a laureate of the Guggenheim Prize in Public International Law, the book reviews editor of the British Yearbook of International Law, co-rapporteur of the ILA Committee on Submarine Pipelines and Cables, and member of the ILA Committee on the Use of Force by Invitation. We are really thrilled to have you joining us, and I'll give you the floor now. Thank you.
Thank you very, very much. I'm delighted to be here and surrounded by friends. But also, I'm really delighted to be here because PLAC obviously has done research on state silence, and it's a great way for us to start a conversation, a long overdue conversation. So today I want to speak about Not All State Silences Speak. This is a new paper I've been working on. And I would like to start with a phrase from the International Court of Justice. Silence may speak. In these poetic, I would argue, words, the International Court of Justice in 2008 described the concept of acquiescence in Pedra Branca, Malaysia versus Singapore. Now, this case concerned a dispute about which state has sovereignty over a particular territory, and the court's reasoning really concerns acquiescence in the context of and in relation to territorial title. But acquiescence permeates the whole of international law, and it is relevant for the identification of customary international law, but also the formation, interpretation, and modification of international agreements. So since it is relevant for the sources of international law, it has the potential to affect all primary rules of international law, from the law of the sea to the use of force, human rights, trade law, and so on and so forth. Now, the court's reasoning in Pedra Branca, that silence may speak, has been quoted by the International Law Commission in its 2018 conclusions on the identification of customary international law. Now, conclusion 10, paragraph 3, states that failure to react over time to a practice may serve as evidence of acceptance as law, opinio juris, provided that states were in a position to react and the circumstances called for some reaction. Now, the ILC has taken a very similar approach to, in another topic of its work, which ran in parallel with custom identification, namely its 2018 conclusions on subsequent agreements and practice in relation to treaty interpretation. Now, here the ILC was concerned with the rule that is set forth in Article 31.3b of the Vienna Convention on the Law of Treaties. This rule stipulates that the interpreter is obliged to take into account the subsequent practice of some parties to a treaty that establishes the agreement of all parties to the treaty about the treaty's interpretation. Now, to identify how an agreement between all treaty parties can be established by the subsequent practice of only some parties, the ILC states in conclusion 10, paragraph 2, and I quote, "Silence on the part of one or more parties may constitute acceptance of the subsequent practice when the circumstances called for some reaction." Now, here the ILC did not expressly refer to the court's reasoning in Pedra Branca that acquiescence is silence that speaks. However, this is the very reasoning of the ILC. In its commentary to this conclusion, the ILC states, and I quote again, "The International Court of Justice has recognized the possibility of expressing agreement regarding interpretation by silence by stating in the case concerning the Temple of Prof that where it is clear that the circumstances were such as calling for some reaction within a reasonable period, the state confronted with a certain subsequent conduct by another party must be held to have acquiesced." Now, putting aside whether this is the correct assessment of what the court actually said in Prof, the ILC's reasoning is similar to its reasoning in the conclusions on custom identification. Acquiescence is silence that speaks. In other words, it expresses a meaning, and more particularly, it expresses the meaning of acceptance. Now, in this lecture and in the article on which this lecture is based, I would like to reveal a misconception about the significance of state silence in international law, and I want to propose an alternative way of understanding this legal significance. Now, the court's own definition of acquiescence is not clear as to whether acquiescence is silence that speaks. Now, in Prof, for instance, the court said that the state must be held to have acquiesced, not that Siam in that case had expressed acceptance. Since 1998 in Gulf of Maine, and even in its recent judgment in Somalia versus Kenya in 2021, the court defines acquiescence as equivalent to tacit recognition manifested by unilateral conduct which the other party may interpret as consent. So I argue that there is a distinction between state silence that speaks, and I call it communicative silence, and rules of international law, on the other hand, that allow an assessor, for instance, a court or another state, to draw an inference about the state of mind of a silent state from the very fact of silence. Now, I also do not focus only on the meaning of acceptance, which is in fact the focus of most literature in this field. I expand the scope of my inquiry to cover also silence as opposition. And this is important for two reasons. So first, the existence of a dispute is a requirement in order to trigger the jurisdiction of international courts and tribunals, including the International Court of Justice. If a state remains silent in response to a claim by another, it becomes unclear whether the two states have opposing views, and as a result, whether there is a dispute between them, and by implication, whether the court would have jurisdiction. And second, examining silence as opposition strengthens my argument about the difference between communicative silences and state silences from which inferences are drawn about the state of mind of the silent state, irrespective of whether or not the silence is communicative or not. So in the following minutes, I will do the following. First, I will show that silence can be a function equivalent to a speech act, communicating an intended message, and that this differs from, second, state silence which does not communicate a message, but is a fact from which inferences are drawn on the basis of a rule of presumption of acceptance in the case of acquiescence, or a presumption of opposition in relation to dispute settlement. I will demonstrate the differences in terms of the conditions, but also the rationale behind these two categories of state silence. And finally, I will draw some conclusions. So starting with whether state silence can be functionally equivalent to a speech act. So I argue that the conditions adopted by philosophers of language, such as Austin, Grice, and Searle, would have to apply. So Austin, in his famous lectures in 1955 in Harvard about how to do things with words, had insightfully argued that one can commit by saying, I commit, in the context of a conversation. In real life, of course, persons and states do not really use this prototypical language. Instead, the speaker has to use language that both the speaker and the hearer understand as a sign that counts as a promise or commitment. In addition to that, the hearer would have to prefer the speaker to do the promised act, and the speaker has to believe that the hearer would prefer the speaker to do the promised act. So essentially, this is a matter of background expectations that are shared between the hearer and the speaker. So how do these conditions now apply to international law and specifically to state silence? So international law is made through the interaction between states and also between states and non-state actors. So in such a decentralized legal order, the concept of a conversation finds appropriate application. States very often exchange messages and information between them, for instance, by letters, by note verbal, telephone calls, or even address each other in multilateral fora. But for silence to then also count as acceptance or as opposition, much will depend on the behavioral but also legal expectations in which this particular conversation is taking place. So I argue that there are two ways in which we have these types of social or legal expectations. The first one is that silence may have already been coded as acceptance. So it has been pre-assigned the meaning of acceptance. And this can happen either by prior agreement between states or by the declaration of a group or the institution that has the authority to do so. So an example of the agreement of states to pre-assign the meaning of silence to their future, to pre-assign the meaning of acceptance to their future silence, would be the opt-out systems for adopting, for instance, the regulations under the World Health Organization constitution, or the amendment of multilateral treaties through an opt-out system. The example, and a very common example, would be the CITES appendixes, the Convention on International Trade of Endangered Species. And the second example of where silence has been coded as acceptance would be by the declaration of an institution. An example would be the rules of procedure of the International Court of Justice, which already determine the meaning of lack of objection by the respondent in the case where the claimant has requested the discontinuing of the proceedings. Now, second, let's take the case where no coding has taken place at all. So state silence can, I argue, intentionally communicate acceptance by implication owing to the social expectations in that particular conversation with another state. So we definitely need a conversation between the states involved. The second thing that we would need is the relationship between the interlocutors to be such that one is expected to respond to the other. You wouldn't really talk to strangers on the street if you didn't have to. And the third one would be that there is an expectation that the other party would say yes. And this may exist owing to the established relationship between the interlocutors, and especially an example would be because you have usual prior dealings on a particular subject. Now, this is important in practice for two reasons. The first reason is that if we accept that under international law as it is today, states can make an international agreement only on the basis of communicated intention, silence can count as acceptance, but only under the limited circumstances which I just set out, and these circumstances differ from the conditions that are required for acquiescence. And the second reason why this is important has to do, for instance, with the law of state responsibility. So a state, under the law of state responsibility, may consent to what would otherwise constitute an internationally wrongful act. If a state gives consent, for instance, to the use of force in its territory by another state, the use of force is not wrongful. But the ILC in 2001, in its articles on state responsibility, also stated that consent must be actually expressed by the state, rather than merely presumed. So it follows that presumptions that are drawn about the state of mind of a silent state would not constitute valid consent. A state can, in principle, give consent in silence, but only when that silence actually communicates acceptance. So allow me to give you two instances where silence does not communicate acceptance. So the first one is when silence takes place in the normal course of negotiations or interaction between states. And I think this condition also explains the reasoning of the International Court of Justice in cases such as the DRC versus Rwanda or in Belgium versus Senegal, where the court had to identify whether it had jurisdiction pursuant to the jurisdiction clause in a treaty that requires the disputing states first to have recourse to arbitration prior to submitting the dispute to the ICJ. Now, in these cases, the court has found that the disputing states have failed to agree to submit a dispute to arbitration when one state requests the other to organize arbitration and the other one has not responded. Additionally, where a relationship of prior dealings exists between the parties, if a state makes an offer that differs from the usual dealing, silence in response to this offer at best would mean acceptance of the usual dealing, not the new different proposal. So let me give you an example of why this becomes important again in practice. So in the field of the law of the sea, states that have not agreed on their permanent boundaries often establish modus vivendi arrangements, which are temporary and they're of a specified nature. Usually these are about the exploitation of natural resources in the undelimited area. Now, these arrangements differ from permanent boundaries arrangements and agreements. So if in response to an offer to agree on a permanent boundary, the other state is silent, and the only background of that relationship is the modus vivendi arrangement, silence cannot communicate acceptance to make a permanent boundary agreement. At best, silence expresses acceptance to continue the modus vivendi agreement. So then when can we actually find case, when can silence mean acceptance, actually express acceptance? I think this would be in very, very limited scenarios. So an example would be in reciprocal dealings that are recurring, such as if a state leases its territory to another under certain conditions and offered to extend the same agreement under the same conditions may be accepted in silence. And a state can give consent to the presence of military forces of another state silently, but this can happen only in exceptional circumstances when it has continually given express consent and it continues to cooperate on the ground with foreign forces. So this may be perhaps a way of explaining why the International Court of Justice in DRC versus Uganda considered the lack of objection of the DRC. So in this case, Uganda argued that the DRC had authorized the presence of Ugandan forces on the DRC's territory. The court noted that from mid-1997 to early 1998, the DRC had authorized 3 times expressly the military forces' presence in its territory, and on top of that, the court considered that the DRC did not object to the presence of Uganda's military forces. And I think that this may suggest that the court considered that instances of DRC silence in between could be explained as silent consent, because during that very period, the DRC had consistently authorized that action. The 2 states had a very specific established relationship with prior dealings, and the normal expectation would be that the DRC accepted Uganda's forces on its territory, but especially since its forces cooperated with Ugandan forces on the ground. So I now move on to the second part of my talk about inferences from the fact of silence. And now I want to give you an example that comes from a book that I really is one of my favorite books. It's Conrad's Secret Agent. It was written in 1907. And I'm really sorry to those of you who have not read the book, because it's going to be a spoiler. I'm going to give you the end of the book. But I really think that this is a great example for our discussion. So the secret agent in this book is Mr. Verloc. He's a secret agent of France in Great Britain. And one of his instructions is that he has to blow up the Greenwich Conservatory. So he's married to Mrs. Verloc, who doesn't know that he's a secret agent. Mrs. Verloc has a mentally ill young brother. So Mr. Verloc finds it appropriate to actually convince the young mentally ill brother to carry the bomb himself and go blow up the Greenwich Conservatory. On their way to Greenwich, unfortunately, the young man has an accident, and instead he blows himself up, and he dies. So Mr. Verloc returns home. At some point, he reveals to his wife that he gave her brother a bomb, and that's the reason why her brother is dead. So her reaction is complete silence for hours. She's not saying anything. Now, the context is that Mrs. Verloc is a woman of not many words, generally. So he appears to think that, oh, actually, she's now favorable to me, everything's fine. I think it would be an understatement to think that she disagreed because she basically picked up a knife and killed him. So I think what she was doing by being silent was certainly not communicating her intention to kill him. And this would have defeated her whole purpose of killing him. So what happened really is that he presumed that she was favorable to him. Okay? So similarly, state silence is often a fact which is not communicating a state's intention. In fact, I think very often states may want to conceal their real intentions, and that's why they remain silent. However, presumption rules extricate an observer, a court or other states, from an impasse of not knowing how to assess a fact. And in this case, a non-communicative fact. So a presumption bridges a basic fact, here silence, with a presumed fact, here acceptance, or a presumed fact of opposition. Now, I will first explain the conditions prescribed in the presumption rules of acceptance and of opposition, and second, I will explain the reasoning behind having a presumption of acceptance and a presumption of opposition. So starting with the conditions incorporated in presumption rules. A presumption of acceptance from silence requires that the following conditions are met. A state fails to react while it has the capacity to react and has or has construed knowledge of the circumstances that call of its reaction. Now, the circumstances that call for one's reaction here concern a behavioral norm, indeed, not a legal obligation. There's no obligation to react. This is a behavioral norm we're talking about. And that behavioral social norm is that when a state's interests are under threat, that state would normally say no. So here, the expectation and normalcy is that someone would say no. It's not that someone would say yes, as is the expectation in relation to communicative silence that we were just discussing earlier. Now, similarly, a presumption of opposition from silence requires the following conditions. A state communicates its views about the law or facts to another in circumstances where the other state is expected to react, and the other state remains silent. Now, here there is again a behavioral norm involved, which concerns how states behave when there may be a disagreement between each other. So the normalcy or expectation, at least it appears from looking at the standards adopted in jurisprudence, the normalcy or expectation seems to be that a state would clarify that there is no disagreement if there is none. But the silent state here is not really communicating that it agrees or it disagrees. Take the Verloc example. It may be avoiding to communicate altogether, and this may be because it, first of all, doesn't recognize at all the interlocutor as a state for one matter, or it may be silent in order to avoid the jurisdiction of an international court or tribunal. So moving to why we have presumption rules of acceptance and opposition. So presumptions, I think we have to be upfront and honest about this. Presumption rules are underpinned by an element of bias. But why are we giving priority to yes over no or to no over yes in these different scenarios? Now, in both instances, presumptions of acceptance and presumptions of opposition, the reasoning behind them is twofold. The first one is probability, and the second one is normative considerations. Now, in most cases where a state is silent in the face of consistent and clear legal claims against its interests, it actually and really accepts. And in the Lotus case in 1927, the Permanent Court of International Justice considered whether custom permitted a state other than the flag state to exercise jurisdiction, criminal jurisdiction in respect of collision. Now here the court specifically talked about probability. So the court reasoned that states did not protest to such exercise of criminal jurisdiction, and that contrary to France's argument in this case, it seems hardly probable, the court said, that the French government in the Ortiguia case and the German government in the Ekpadana case would have omitted to protest against the exercise of criminal jurisdiction by the Italian and Belgian courts if they had really thought that this was a violation of international law. So the court expressly really takes into account the issue of probability here. But really, probability is insufficient because it cannot account for the cases where the state does not truly accept. So we do need normative reasons for which, in order to justify a presumption in favor, prioritizing acceptance over opposition here. And what are these normative explanations? I think we can explain it as the law giving priority to acceptability of error. And I will connect this to Jeremy Bentham. So Jeremy Bentham, whose auto icon is displayed at UCL, and after whom, in fact, the building of UCL Law's faculties is named, wrote in 1825 that in doubtful cases, the judge should consider the error which acquits as more justifiable or less injurious to the good of society than the error which condemns. So similarly, I think that we accept the possibility of error here that the silent state does not truly accept or does not truly oppose because there is a goal that is much more valued. And in the case of presumption of acceptance for norm creation, the law prioritizes the predictability of legal relations between states, but I also think that it prioritizes the avoidance of impeding the development of the law. Now, similarly, the presumption rule on opposition can be explained by probability and normative considerations. So when a state is faced with a claim of another, it is more probable that it will be efficiently clarifying its own position so that the impression about a dispute could be dispelled. In the absence of any clarification of one's position, it is probable, again, that a state chooses not to react because it disagrees. But probability, again, is insufficient to explain and account for the cases that the state is silent because, irrespective of whether it disagrees. So here, the normative considerations are again needed. And the paradigm that has been established by international courts and tribunals, I think, accepts the possibility of error, but the silent state does not truly oppose because there is a goal that is more valued, and that is the preservation of the judicial function. If opposition is not presumed from state silence in these cases, any respondent could simply defeat the jurisdiction of an international court or tribunal simply by remaining silent. So I would like to conclude by coming back to poetry as I started. So the following phrase is often attributed to the Nobel Prize and laureate, William Butler Yeats: "What can be explained is not poetry." So stating that state silence can speak is not poetry. It is correct, it can be explained. if state silence is functionally equivalent to a speech act intentionally communicating a message. But when we say state silence may speak, to describe instances where inferences are being drawn from silence about the state of mind of the silent state, I think that phrase should be best understood as poetry. The silent state in these cases is not communicating. In fact, it is likely that it is trying to conceal its intentions by remaining silent. Now, communicative silences differ from non-communicative silence-based presumptions in terms of their conditions, in terms of their operation, in terms of the rationale behind them. However, I think that ultimately caution is necessary in relation to both. In relation to communicative state silences, caution is called for because a communicated meaning is assigned to silence, which is an ambiguous conduct. But in relation to presumptions from state silence, caution is called for because any presumption about a state's state of mind involves a risk of being erroneous. So thank you very much, and I look forward to the discussion.
Wonderful. Thank you so much, Dr. Azaria, for that talk. And I failed to mention in the introduction that you are also, as part of this really exciting grant, I think building kind of a silence and international law community around the world and really bringing together those that are working on this topic. I am not going to take moderator's privilege just yet, so I will open up the floor to questions. And Dustin, might I ask you to circulate the mic? Thank you so much.
Yeah, thank you so much. I have a question. So while I was listening to your presentation, I was thinking that the distinction between communicative acceptance, I'd say, silence, and the inference is our position towards status quo. So when it's all about preserving the status quo, we're fine with communicative silence, but when we're thinking about changing it, then we need something more. And then you refer to Bentham and about errors, and there is all this literature about how false negatives are better, are less onerous than false positives because of the loss of version. So does it all boil down to that after all? So it's not about preserving the judicial system, but about preserving the status quo?
Back to you.
Yes, thank you so much for this question. I'm not so sure that the one necessarily prioritizes change over status quo. Perhaps if you saw that the conditions under which communicative silence can express the meaning of acceptance as much more difficult a case because the conditions are higher, yes, that preserves the status quo because it's much more difficult to achieve the meaning of acceptance through communicative silence. That's the argument of this paper in any event. But I think also the acquiescence scenario, to my mind, it strives to strike a balance between too much change and too much stability, because it allows, first of all, for change through acquiescence, but the conditions are quite high. So you still have a balancing act within these rules, the conditions required in order for acquiescence to actually exist. In terms of false negatives and false positives, that's an interesting point, and I think I would really like to reflect on it a bit more before taking a clear position on it. But yeah, that's a very interesting thought, actually. Thank you for that.
Yeah, absolutely. Yes, please.
Hi, Dr. Azaria. Thank you so much for coming. I was wondering about how you think about the distinction between silence as an absence of speech and silence as an absence of action, because it seems to me that in the example you give about occupation of territory and how cooperation with forces might make that silence communicative, it seems that you could make an argument that that's not silence at all because the action is the speech in that case. So I'm wondering how you think about that.
Yes, actually, thank you so much for this question. I think you're right that a lot has to do with one defined silence in the first place. In my project, at least, I do not focus exclusively on the absence of verbal conduct, I take into account inaction in terms of physical conduct, lack of physical conduct as well. But I think the point that you're making is slightly different. So you're saying that actually this is not a case of complete silence. So the way I would describe this is that there is also a different taxonomy between complete silence and partial silence. So here there is lack of objection, and then it's accompanied by actual conduct on the ground, physical conduct on the ground. So I think we can have both, but the legal relevance of absence of speech is there. It wasn't lost at all from the court's reasoning. Both were legally relevant.
Yes.
Thank you so much. I wanted to ask you perhaps to elaborate a little bit more on the very last point of analysis, which is the question of normativity. So on the one hand, you spoke of the normative interest of predictability and I suppose the extent to which law does address and regulate behavior, which on the one hand refers to some traditional understandings of the rule of law, as it were, and on the other hand also it kind of connects with your probability justification. So the probability justification is not only an efficiency predictability, but it's also a normative rule of law type of justification. And on the other hand, my question was whether you're also considering that there can be a type of taxonomy in relation to normative interests and how they influence inferential assessments, including in terms of the nature of particular norms and the now age-old distinction between, bilateral and communitarian values.
Yeah.
And including in relation to potentially the thickening of the institutional framework for the enforcement and interpretation of these norms. I'm not suggesting that this would necessarily only go in one direction in terms of inferring acquiescence or inferring obligation. It may be that in some ways it goes in the opposite direction. Maybe the use of force, is relevant in that. But that's my question: is whether there should be another normative taxonomy there.
Yeah, that's actually a very good question. I think this paper, frankly, could have been written on the basis of a structure that reveals the normative concerns behind attributing the meaning of silence or inferring silence from. So, for instance, estoppel on top of this as different from acquiescence and how it relates to silence, but also it does, however, reflect, the actual paper does reflect on the normative reasons behind the coding in particular cases. So I think that you're right that it could be written in a different way, although I don't think that this was your particular argument, but I'm still thinking about it. You're saying that perhaps there is, because of the distinction between bilateral norms and communitarian norms, perhaps we have a different approach to state silence depending on the rule that we're looking at. I think that is a very valid question. In fact, it's a question that I'm taking into account for the current project I'm doing. At this stage, my approach to this is to say that perhaps silence might not necessarily be relevant in relation to jus cogens, for instance, because silence does have a connection with consensualism, so I don't see how it could possibly be relevant within the jus cogens elevation or modification, etc. When it comes to erga omnes partes obligations as opposed to bilateralism, I think that it raises wider issues about who is expected to react in the case of a violation of the prohibition of use of force, the prohibition of aggression, for instance. Who is expected to react? Because if we actually follow the Articles on State Responsibility approach, where even states other than the injured state are entitled to react, at least by invoking the responsibility. There's a question about countermeasures, but still they have a right to invoke responsibility. So if we actually adapt just take this and then transpose it in the normativity issue, so that whether we can change the law like this. I think we're just flipping the side completely. So just because the states other than the injured state are silent, we're just changing the rules very fast. So I find this not necessarily an appropriate way of assessing, just transposing standards into the communitarian rules. And that's where my thinking is in terms of the differences. And of course, the thinking in enforcement and institutions, absolutely, the more we have institutions, the more communication we have between states. This is what international institutions do. They are permanent fora for communication between states. But the more communication we have, the more knowledge we have. So the more we meet, it's easier to meet the threshold of knowledge. And then there is a question of whether that entails change or confirmation, of course, of rules, but also the danger possibly is change. But I don't think that we should necessarily see change as a danger. It can be a danger, but it can be actually very positive, adapting to scientific knowledge or protecting species that we found out that now are endangered. That should also be taken into account.
Yeah. Sorry.
One thing I'm thinking about in this larger context is the value of efficiency and the value of sort of acknowledging these broader norms and how your view of silence would interact with that. I'm really curious because I think accuracy is very important, but I also appreciate the need for an efficiency aspect of CIL. So I was wondering if you could speak to that.
Absolutely. Thank you for that. Actually, that's one of the normative reasons underpinning for instance, the introduction of opt-out systems for the adoption of World Health Organization regulations. That was, in fact, explicitly stated in the preparatory works. Efficiency was seen as the priority, and that's why they created the silence opt-out system. The same would go for the CITES, for the Convention on International Trade of Endangered Species. Efficiency is something that states pay attention to, and that's why they introduced these particular mechanisms. But of course, these are, again, coded, so that means that there may be something about these rules that have to do with harmonized standards, or standards that are technical, that states may feel more comfortable, first of all, more comfortable, or they feel that they're more susceptible to change because circumstances are, the change in terms of circumstances can be fast, and they have to address global health issues or global environmental issues. But when you come outside of these special scenarios, I think there is a question about efficiency in terms of whether the default rules on, say, especially acquiescence, whether it is geared around efficiency in that way. I think there is, again, a balance between this reasonable period. So you could say that there is incorporated some sense of efficiency, but what is reasonable will depend on the circumstances, and it can be 40 years or 3, but it's certainly not a month. So I think we're talking about really different scenarios, of course, here. But efficiency is part of the game, the game, of course. Yeah. Thank you so much for that question.
Yes, so Doctor, thank you so much for your presentation. I couldn't help but wonder whether we should probe into how we assess silence, whether it's an assessment on a singular scale or on a sliding scale, especially considering that the thresholds of evidence and appreciation differ from one system to another. To refer to, for example, your reference to Jeremy Bentham, he was referring to a criminal procedure, I mean, from the language that was used, which would apply the principle of in dubio pro reo, when in doubt, in favor of the accused. The states don't quite enjoy that presumption. In fact, in the Inter-American Court of Human Rights, for example, they would be subject to a pro homine presumption, a presumption in favor of duty, and a presumption possibly in favor of liability. So that's my first of two questions. The second one is, I couldn't help but draw contrasts between the language of silence in customary international law with the age-old debate on jurisprudence and social contract theory and the value of consent, implied consent, tacit consent, and of course the principle of beneficence. I wonder, would it matter whether we were dealing with customary international law, a treaty in general, or a treaty of a constitutional nature? Because it's one thing to say that we have impliedly consented to a contract, a treaty qua contract, but I think it's possibly another thing to say that we have subscribed to a legal system through silence. I think a professor here at Harvard has used this in an example that perhaps implied consent may indeed be a form of consent, but it's quite a difficult pill to swallow to say that by walking on a government-paved sidewalk that I have ratified the Constitution. So would distinctions lie in my first question, the system, and in secondly, the nature of the treaty in which we're dealing with? Thank you.
Dr. Azaria, if it's okay with you, could we take a few questions
Oh,
and then come
apologies.
back
Yes,
to you
of
to
course,
close? Not
of
at all.
course, of course.
Dustin, I think we have Veronica. You want to go first? Okay, thanks.
It's more of a reflection than a question, because I know we don't have access now to the whole article, but without the lecture, I kept thinking about whether the conditions which you suggest, which have to be present in order to enable us to infer meaning of a silence, whether they ultimately might trap us in a way by almost always being present while assessing the state conduct in certain circumstances, and always almost not being present in assessing the state conduct in other circumstances, depending on which sphere of law we are talking about, which circumstances we are talking about. For example, if we concentrate on the judiciary system and like on silence of the states in ICJ proceedings, then if we try and apply the conditions, whether they sort of trap us in a system where we are unable to assess it on a case-by-case basis, but rather would always keep coming to the same results. It's like not a critique, but just something I kept thinking.
I completely understand.
The lecture.
One final question, if that's okay.
Yes, of course.
Thank you, Dr. Azaria. My question is about externalities and direct injuries when it comes to state silence. And I guess I'm sort of curious, when there's a direct injury to a state, then silence is perhaps more communicative. But I'm curious about state actions that tends to have positive or negative externalities. So it affects the community of states, but there isn't really a good direct actor to speak on it. And I think I'm especially thinking about this in the cyber context, where, for example, you have cyber enforcements abroad that's publicly good, so nobody really complains about it. And then in the free speech context, where states are increasingly underhandedly taking down content through informal agencies, and because individuals are affected and not states, states are also silent on that. And so I'm kind of curious about your thoughts on the role of silence with externalities more generally, and how to perhaps create accountability, or is it possible?
Okay. Very interesting questions. I think, let me just address your question, which I don't take as a criticism. I see this as absolutely a valid point to make. But I think that we need some methodology that can be applied objectively to all cases in order for us to be able to say that we're transparent about what the law is and how we can actually assess and interpret a state's conduct as meaning something or not, or inferring from it some meaning, or attributing to it some meaning. So that's why I think we have to have objective conditions that will be applied to each case. Whether these will trap us, I think that's the question you're asking, and whether essentially, at the end of the day, we're reaching the same result. Is that your point, that we're reaching the same result? So why? Why are we having these different conditions? Did I understand your point correctly?
It's like it seems that the conditions suggested are that we need to have a discussion, that we need to have the expectation that the state might say yes, and that we need to have an expectation that the state should reply in the circumstances. My concern is whether these particular conditions, by being like this particular methodology, can trap us.
So that we don't attribute the meaning of acceptance or opposition to silence. So we don't consider them at all relevant because we have to follow these conditions. Is that what you're asking?
I guess so, because it just seems that within the context of ICJ proceedings, we will always be applying these conditions, as you say, objectively as a methodology, but then the outcome would always be the same, and whether this is good or bad is my next question in a way.
Yeah, I'm not so sure, however, that if you apply, for instance, the conditions that apply for acquiescence would render the same results necessarily as in relation to communicative silence. In fact, I think that it is likely that when something is communicative silence, you could meet also the criteria of acquiescence. But if it's not communicative silence, it's extremely unlikely. It is likely you still have the possibility of going for acquiescence. So it's much more difficult to get to communicative silence. Why that it is important? I think it is important for just what it's worth. I think it's important to explain what the law does and why we're doing things, and that at the end of the day we are presuming something about the state of mind of someone. They're not expressing anything, so we have to accept that, know why we're doing this, and then address it as a presumption. At least that's why I'm trying to reveal this. The point by the colleague here on the differences between custom and treaties, and how silence may be seen in a different, may have a different function and perhaps be more liable for change as opposed to maintaining the status quo in custom or treaties. I think that was part of your question to some extent. I think that is reasonable as a discussion. First of all, for the mere fact that for general custom, all states would be involved in terms of opinio juris, right? So you are, while in treaties you can have 2, 3, 5, even 160, but certainly not over 190. So things will definitely differ, and also with treaties you have institutional structures. You have a different type of thicker communication, much more knowledge through institutions. With treaties on top of that, and the constitutional treaties that you're referring, for instance, very often we'll have expert treaty bodies. So I'm thinking about, I hope that we mean the same thing by constitutional treaties. We mean human rights, as an example, human rights treaties. So let's take the ICCPR, the International Covenant on Civil and Political Rights. The Human Rights Committee has been mandated with certain functions of supervising the implementation of the ICCPR. It makes interpretative pronouncements about the ICCPR. So there will be a question of whether the silence of treaty parties towards the pronouncements of the Human Rights Committee can actually communicate acceptance or even entail acquiescence to the pronouncements by the Human Rights Committee. And here, obviously, first of all, you have a different structure comparing to custom, certainly, because you don't have this communication between a non-state actor and a state in order for a silence to have that meaning or that inference to be drawn. And there is then the separate question of whether you could possibly see as a state being expected to react to a non-state actor's pronouncements. And here I think there will be two separate questions. The one will be well, you have created this body for a reason, and you want it to act efficiently and actually fulfill its purpose. So yes, you would be expected to react to it. On the other hand, states would probably be very averse to this idea. In fact, they have been expressly a few years ago. So I think these are the different dynamics when it comes to bilateral treaties and constitutional treaties, but also separating custom from treaties. I hope that answers your question. And as a final, should I add, or? This could be the last. Yes. Thank you very much for your point on cyber. And I think, if I understood correctly your point, you're saying actually states will not necessarily have an interest to react in the first place, that they're not going to enforce. In fact, many states are not even discussing whether they're silent about whether IHL applies to cyber, right? So we're not discussing whether there has been a violation here or there. We're not even discussing whether this branch of law applies. So let's put this aside for a moment, but your scenario also relates to the case of Syria. And what I have in mind is the use of force of the UK, US, and France a few years ago against Syria for the use of chemical weapons against civilians. The UK has made a legal claim. The US and France have not made a legal claim, but the UK has made a legal claim. It has said, we consider that the law permits us to do this. Other states have not really reacted, and I think the reasoning behind this is not necessarily an acceptance of that the law has changed, but there is this moral impetus to not challenge this, because on the ground there was this perception that, yes, civilians are dying from chemical weapons, so we don't want to really react here. But of course, this is a one-off, or try to consider this as a one-off case, or politically try not to raise it as an issue. So I think what you're raising is more generally the question of, okay, silence might actually have some diplomatic, political considerations behind it. And perhaps we might need to take this into account when we are assessing whether this is acquiescence or not. And there is a question of whether these are part of the circumstances that call for some reaction or not, whether this is knowledge, whether we should see it as a rebuttable presumption. So I think there are different ways of addressing this, and that's what I'm considering. I hope I answered your question.
Thank you so much. Please join me in thanking Dr. Azaria.